Hello and welcome, everybody. Thank you for joining me today. Our topic is how to start your estate plan, estate planning basics. My name is Lynn St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning. We serve clients in the state of Washington and in North Idaho. Today's topic is intended to make understandable, something that's a pretty complicated or can be a complicated subject, and that is estate planning. So my goal is to not get terribly complicated today. I think one of the reasons that people shy away from doing estate planning or anything is when it gets too complicated, our brain's just going to say, just don't do anything. And that's a normal human reaction. In order to help you understand how to get started on your estate plan, therefore, I am going to simply keep things basic, as simple as I possibly can. If you have any questions, please feel free to put them in the chat, and I will answer the questions before we're done today. So, a basic definition of estate planning. Estate planning is the legal process through which a person protects themselves, their autonomy, their assets, and during their lifetime and upon their death, directs where their assets go, who will inherit. That's basically what an estate plan is. The details are where we get kind of caught up, and that's where it gets confusing. Who needs an estate plan? Oftentimes people think, I don't need an estate plan. I don't have any assets, or my assets are modest. Estate planning is only for rich people. That's a common misconception. Estate planning is for everyone. The type of estate plan will differ depending on what your circumstances are. Your situation will be different than your neighbors, your children's, friends. And that's where people get kind of confused, because what they might do is they can compare what their attorney said that they need with the neighbor, and the neighbor said, oh, no, my attorney said this is better. What is better depends on your situation. Who needs an estate plan? If you are an adult, you need an estate plan regardless of what your asset level is. If you have college-age children, they need an estate plan. And you might say, how could that be? The kids have nothing. Well, when I say that everyone who's an adult needs an estate plan, what I am saying is that they need the fundamental estate planning documents to protect them. And we're going to get into some detail as to what those estate planning documents do. But the fundamental estate planning documents are your living documents. Those include your durable power of attorney for financial matters, for healthcare matters, and your healthcare directive, which is also called an advance directive or a living will. Those are your lifetime documents. You need documents that will distribute your assets upon your death. Typically, those documents are your will or your trust. We'll talk about those. As I mentioned, everybody's situation is different. So what is a basic fundamental estate plan for them will be different than for another person. So let's talk about you versus your college age child. And you might say, well, why does my college age child need anything? They have no assets. No, but they're an adult, and they are therefore their own decision maker. And as long as they are legally capable of making their own decisions, great. As long as you're legally capable of making your own decisions, great. But what happens when, for some reason, a person can't make their own decisions? It's at that point, and you might say, why can't they make their own decisions? Well, it could be an accident, a car accident, a stroke, a heart attack. For certain people, it could be dementia. There's many, many reasons why a person can't make their own decisions, why they can't manage their own affairs. If that's the situation, that person needs to have a durable power of attorney. Those documents allow somebody else to make decisions during a person's lifetime. So we're going to get into that a little bit. But what I'm saying is, you're thinking my college age kids don't need anything. Yeah, they do. They need durable powers of attorney. And most of the time, people don't realize that. You're probably familiar with a will and a trust. Those are the documents that say where your assets go when you have passed. All right, so let's get into these basic estate planning documents. What happens if you don't have them? So what are they, and what happens if you don't have these fundamental estate planning tools? First of all, we're going to focus on living documents. Those are your durable powers of attorney. So a durable power of attorney is an estate planning document that you would sign where you designate someone to make decisions for you in case you can't. If you lose capacity, if you can't manage your own decisions when it comes to finances or for healthcare, somebody needs to be able to make those decisions. So it's through a durable power of attorney document that you grant authority to somebody else to make decisions for you if you're not able to do so. Under the durable power of attorney statute, which in Washington is RCW 11.125, it's very important that specific grants of authority be included depending on what you want that person to be able to do. That person who you designate under your power of attorney is called your attorney in fact, your agent, your proxy, your POA. All of those mean the same thing. That's the person that you've given authority to manage your affairs if you can't. The document is called durable for a reason. Durable means that this grant of authority to somebody else to make decisions for you continues even if you lose capacity, which is exactly what the document is intended to do. For most people, if they're capable of managing their own affairs, they're going to do that. They don't want somebody else to step in and manage their affairs. So the power of the durable power of attorney is that it is durable. It continues in effect even when you are not able to make your decisions, which is exactly what we want this document to do. Under the durable power of attorney, you have the ability to say, hey, I want my husband, my daughter, my son, whomever to be able to manage finances if I'm not able to do so. I want my husband, my daughter, my son, whomever I want to designate to make medical decisions for me, to talk to the doctors if I'm not able to do so. If I'm able to do so, I'm going to make those decisions myself. But the power of attorney protects you in case you lose the ability to make such decisions. Under the durable power of attorney statute, you want to include what authority it's important for those persons to have. Now, backing up a little bit, you heard me say my husband, my daughter, my son. They're not all going to be making decisions for me. I'm going to do it in a cascading order. First position is my husband, then my daughter, then my son. Why do I name these successor agents? The reason that I do that is perhaps my husband and I are in that same auto accident, so he can't make decisions for me. So then my daughter needs to step in and make decisions for both myself and for my husband. You have to have cascading order of successor decision makers so that that position is never empty. There's a reason for that. I'll get back to that. What kind of authority should you include in this basic fundamental document? I recommend that you include what authority so that they can actually manage your affairs. So as an estate planning and elder law firm, we often help clients protect assets during their lifetime and also after their death, especially against long-term care costs, the number one threat to financial security. So our durable powers of attorney are going to be more comprehensive. They're going to contain more grants of authority than a simple, basic, durable power of attorney. Again, what we're talking about today is estate planning basics. So I don't want to spend a whole lot of time talking about what an elder law attorney would include in a durable power of attorney. Those are the details I think that often bog people down when they come to what document should I sign? What estate plan do I need? Is that they get bogged down in the details. So what I'm going to say is everybody needs a durable power of attorney for finances and for healthcare decisions. It protects the person in case they lose capacity, they lose the ability to manage their own financial affairs and their own medical affairs. Designate successor agents and make sure that the person that you're designating, the people you're designating to make decisions for you, are people that know you, if you have that ability, people who you trust, and people who will be your voice in case you can't speak for yourself. Make sure your document is durable. A non-durable power of attorney isn't going to do you any good if you lose capacity. For people who don't have family members or friends that they can name, there are professional fiduciaries who know what they're doing, who will fill that role, who, in case you lose capacity, will be there to manage your own affairs. Yes, those people will require a fee, and that often puts people off. It's like, I don't want to pay anybody for that role. Well, if you don't have any family member or friend or anybody that you could otherwise designate to be your decision maker, you really don't have a choice. You need to name a professional. What happens if you lose capacity and you don't have durable powers of attorney? What's going to happen? In that event, the state will step in and will, under this guardianship, conservatorship proceeding, where you would be adjudicated to be a ward of the state, somebody who lacks capacity, somebody who can't manage their own affairs, and then the court will appoint somebody who is a professional, who is a certified professional guardian, then to be appointed to manage your affairs, to make decisions for you, to manage your finances. So either in the event of incapacity, either the person that you want and you've named will manage your affairs, or since you didn't do the durable powers of attorney, the state will step in, will designate somebody, perhaps somebody you've never met, to manage your affairs, and all of that will be under court supervision, which means reports to the court. The court has to grant orders and authority to do things, budgeting, personal care plan. It is an intrusive and costly but necessary legal proceeding for those people who don't have their durable powers of attorney in place. I really like to emphasize how important the durable powers of attorney are, because oftentimes people, when they think of an estate plan, they think, I have a will, I have an estate plan, I'm good, I'm covered. And what that shows is that there's a lack of understanding for what really are the critical components of an estate plan. The critical, and in my opinion, the most important estate planning document you can have is your durable power of attorney. That will make sure that no matter what happens to you, your affairs are not in the court, are not supervised by the court or an affair of the estate. They're kept personal. Your autonomy is safeguarded, because the people who would be managing your affairs, if you can't, are the people that you want to without any court intervention. So if you only have a will, you don't have your life planning documents, your durable power of attorney, for example, you're missing the key fundamental document. That's the document that everyone needs. People without assets need a durable power of attorney. See, a will direct assets on your death, but during your lifetime, people, whether they have assets or they don't have assets, if they lose capacity, they still want to make sure that their affairs are managed by somebody that they know and trust, not by the court. Your kids, for example, your college-age kids, heaven forbid that they're in a car accident or something terrible happens to them, but we all know that accidents do happen. Estate planning, and maybe one of the reasons that people kind of shy away from it, it's planning for worst case scenario. And planning for worst case scenario is not necessarily fun. And you don't want to think about, well, what if something terrible happens to my adult child, the one who's going off to college? If it does, though, you as the parent want to be the one who's there that can step in and take care of whatever needs to be taken care of. With the kids, not likely to be so much financial. It's more about medical. It's more about talking to the physicians and speaking and advocating on behalf of your child, getting information, being able to direct your college child's care. So durable powers of attorney, this is what I say. Every adult needs them, even people who have no assets. Why? To keep the state out of everyone's business and to keep that business within the realm of the family or people that you trust. That's durable powers of attorney. And they are the most important documents, in my opinion. Other living documents will include what is commonly known as a living will. It's also called a healthcare directive. It's also called an advance directive. They all mean the same thing. What is that document? That's the document that you sign where you say, if I am at end of life and my physicians have put in writing that I am in a terminal condition, permanent vegetative condition, that with all reasonable medical probability, no medical treatment is going to make me better, return me to an equality of life. It's just a matter of prolonging the dying process. Do I or do I not want those measures implemented? They're often called heroic measures. That document is important for everyone, regardless of asset level, because what it does, again, it helps protect the person's autonomy, their decision-making authority. It says in writing if heroic measures are desired or not. Generally speaking, though not always, people typically say, if I'm at end of life and the doctors say nothing's going to make me any better, it's just going to prolong dying process, let me pass peacefully with comfort measures so that I don't suffer, so that my family doesn't suffer. I don't know, maybe you can recall back, there's been cases that have been in national spotlight before. It's been a while, but maybe some of you recall the Terry Schiavo case out of Florida. That was a woman in her 20s, and she suffered an extreme health event where she was in a permanent vegetative condition, and she didn't, being in her 20s, I believe, she didn't have any of these documents that we're talking about. She didn't have this advance directive. So there was a disagreement between her husband and the parents of the incapacitated woman. And because of that, her health care and all the decisions and whether to give her heroic measures was in a very public forum. It wasn't just decided by what her document said, because she didn't have a document, and there was disagreement between her family. So it went up into the public eye, I believe into the Florida legislature as well, as to what the outcome of her case would be. So that's an example of one of the reasons that people do need to have these advance directives. It helps, just imagine that you or a loved one is in this terrible condition. And that's horrible to deal with. But beyond that, now your family is in disagreement as to what the healthcare measures should be. Adding that extra element of angst and upset, it's kind of hard to imagine how terrible that was for them. One of the ways to make things easier for your family in case something bad does happen to you is to have these documents in place. With these documents in place, if you say, I don't want any heroic measures, and this is the person who's going to be my healthcare agent through my durable power of attorney for healthcare to speak on my behalf, then what you would have wanted will be followed. Somebody will be your voice on your behalf. The family upset will be as a result of whatever they're dealing with your health condition, not this legal battle that would arise without these documents. And do recall that if you don't have any of these living documents in place, what happens if there is a disagreement or if you lose capacity? the state steps in, a guardianship will occur. Somebody, the court will have the final say so on your life. And that can be really upsetting and disruptive, to your family who's really impacted by that. So the living documents are very important to have. Those are your durable powers of attorney for financial matters, for healthcare matters. It can be a combined document or it can be separate, and your advance directive, which says what your end of life wishes are. Sometimes people at this point say, well, I don't want to be resuscitated. And how do I ensure that that's going to be the situation? Because I'm going to put in my healthcare directive, I don't want to be resuscitated. And that's all well and good. You can include that type of direction, but keep in mind that your healthcare directive, your advance directive, your living will doesn't come into play until some doctor has put in your medical record that no medical treatment is going to make you better. Well, if you have had a heart attack and you're not breathing, that's not the situation. That's the situation when 911 is going to be called. The emergency responders are going to show up. They're going to give you CPR and try to get your heart going. That's simply how emergency responders will react. If you don't want that, if you know that your medical condition is such that if your heart stops, that's it. You want to be the end. You'll need to have a different document in place. And it's not a legal document that an attorney will prepare for you. It is a medical order. In the state of Washington, it's called a POST form, physician's order on life-sustaining treatment. That is the doctor's order that says, in the event this person's heart stops, they're not breathing, you can check the box that says DNAR, do not attempt resuscitation. That typically is a form that you will fill out when you're at your doctor's office, because it is a medical discussion to have. And once that document is signed, you are going to want to put it in a very conspicuous location so that if you do stop breathing and 911 is called, when the emergency responders arrive, they'll look on your refrigerator, for example, and they'll see that lime green form there, and they'll take a look at it. And it's very clear. It'll either say, do CPR or don't do CPR. That is a way to ensure that if you don't want resuscitation efforts, you won't get them. But that's not something that a lawyer's office is going to provide for you in your estate planning documents. That's an order that you get from your physician. Without an effective POST form in place, the emergency responders they're legally obligated to attempt resuscitation efforts. So what we've talked about so far are the fundamental estate planning documents called living documents, your durable powers of attorney for health, for finances, your advance directive, also known as your healthcare directive. Those are the basic estate planning documents. I've tried to avoid too much detail about, what should be in your durable power of attorney? What grants of authority should you have if you want to protect certain assets? We have other places where I talk about details about what should be in a durable power of attorney. I'm not going to include that in today's talk because I don't want to get bogged down in those details. Let's move on to what happens on your death. What legal documents do you need? I'm pretty confident that everybody listening to this has heard of a will and a trust. So people think, okay, I've got a will, I'm good. I don't need any more estate planning documents, or I have a trust, I'm good. That's all I need. These legal documents, your will or your trust, primarily are intended to pass your assets when you have died. A will is commonly recognized. It's a document that you say who you are, who's your family, where do your assets go on your death. That's the direction. In Washington, and especially, there's certain legal formalities that must be followed that other states might not have. But in Washington, you need to make sure that your will is done correctly following those formalities. A trust, and we're going to get into more detail on trust because trusts are a bit more complicated. I'll try to simplify them, just saying that they're a little bit more complicated. But a trust is intended to have the same effect, which is on your death, where do your assets go? Oftentimes people say, I have a will, I'm good, everything's going to go automatically on my death. That is a misunderstanding of how a will works. If you have a will and no other type of planning for what happens on your death, your estate will be probated. We'll talk about what that means. Common misconception is people think, I've got a will, I'm done, there's no probate, everything just will go automatically on my death. That is not the case. If you have a will and no other planning on your death, there will be a probate. When it comes to a trust, people often think, I have a trust, I'm good, everything's done. On my death, everything will go automatically according to the terms of my trust. Again, that's not necessarily the case. So when it comes to a will, and we're talking very simply here, a will means that there will be a probate. When we're talking about a trust, if a trust is done correctly, it means there won't be a probate and assets will pass without the necessity of filing a probate with the court. Let's focus on the will for just a minute. Based on what I just said, why in the world would anybody ever want to have a will if instead they could have a trust that totally avoids a probate? It's a great question. It depends on what your situation is. In Washington State and in Idaho, our probate procedures are pretty simple, though you do have to follow all the steps and dot the I's and cross the T's. Typically, that means an attorney has to be involved. If an attorney has to be involved, that means legal fees. If you have a will, it's going to be probated. There's going to be legal fees. And you're probably asking me, why in the world do you want a will then? Again, it depends on what your situation is. So let's talk about the situation where it's a young family and they have minor children. Mom and dad are killed in the car accident. What's going to happen to the minor children? Who's going to be their guardian? And who's going to manage their money? Because minors can't manage their money. So for a family situation, a young family situation, we will often recommend that they have a will. And in the will, it contains a trust for the minors' money and nominates a guardian in case both mom and dad are killed. When you're dealing with minor children, the court has to appoint somebody as the guardian. So you want to make sure that you've nominated who you want. How do you do that? You do that through your will. When it comes to minor children, they can't be in charge of money. So how do you manage their money? You create a trust within your will to receive your children's money, and you appoint a trustee, somebody to manage the money. One of the reasons that people get confused, because when we're talking about a will versus a trust, I just combined the two and I said your will contains a trust. So when a will has inside of it a trust, that's called a testamentary or a testamentary, whatever your preference is, trust. It means the trust is in the will, which means that the trust won't be created until the will takes effect. When does a will take effect? On somebody's death and not before that time. So one of the things that I think people get confused about is they go, I just want a simple will. And then they look at it and they go, why is there this trust in my will? Well, because you need a trust for your minor children. Or when we're assisting clients protect assets for their surviving spouse against long-term care costs, or making sure that tax trusts are funded, we'll often put those in a will, which will require a probate, and then trusts are created. So I think that that's one of the primary reasons that people get confused about estate planning documents, is that you hear of will and you think that's a standalone, that only is, comes into effect upon death. True, but within it there could be trusts. So that leads to some confusion. Anytime you hear the term and try to understand trust, that's where the inquiry starts. It doesn't stop. So I'm trying to, without confusing everybody, explain more about trust. So let's dig in and let's see if I can be successful with simplifying trust. So as a caveat, you've already heard me say trust can be complicated and trust can be confusing. So I'm going to talk about the different types of trusts and what they're intended for, what is their purpose. We've talked about testamentary trusts. Those are the trusts that are in your will and that will be created upon your death through your will and through the probate process. If it's not a will created in the trust, if it's created during your lifetime, that is called a living trust. A living trust is also called an inter vivos trust. This type of trust is not in your will. It is a trust you create while you are alive, and you do it for a very intentional purpose. So a little while ago, I said that trusts can avoid probate. So a very common and probably the most well-known type of trust is what we call a revocable living trust. A revocable living trust is an estate planning document you sign while you are alive with the primary purpose likely to be, I want to avoid probate on my death. For a revocable living trust to work as it's intended, you need to make sure that you fund that trust. And this is where people run into troubles, because oftentimes people don't understand what is a trust. Trust is a legal entity you have created by signing a document. You likely, since you created it, you're called the grantor. The trustor means the same thing. You're in charge of the money, so you're the trustee, and you're the beneficiary of the trust, so you're the beneficiary. And on your death, you want to go wherever, and you say who the next beneficiary is. I think one of the reasons that there's so much confusion is like, well, it sounds like I just own this asset outright, so how is it different when it's in a trust? In fact, when it's in this kind of trust, you don't even get its own tax ID number for the trust. You use your Social Security number. You don't file a separate tax return. So it doesn't even feel like it's a legal estate planning entity separate of you. And because of that, people often forget about their trust and they don't understand how they're supposed to manage their trust so it works as intended. And when I say as intended, what I mean by that is that the assets on your death go to the next person that you want to receive the assets. In order for the trust to work as it's intended, you need to put your assets in the trust. What assets? Your house. It needs to be deeded into the name of the trust. If you own the house in your name, you need to do a deed that deeds it from yourself to yourself as trustee of your trust. You need to record that with the county. People often forget to do that. And if they don't do that, then the trust doesn't work as intended and it will go through probate. Because if you have, you know that if you have a revocable living trust, you also have a will that's called a pour over will. What that is that's the will that captures all the assets you forgot to put in the trust, which is common. And there's a probate to gain control of those assets when you die and put them over into the trust. So not only do you have a probate, but you have a trust administration because the trust wasn't funded properly. Other assets that you put in the trust are your bank accounts, your investment accounts, whatever assets you own. Typically not put in the trust would be your 401k or your IRA. You need to make sure that those assets are directed to pay where you want them to pay. Having said that and highlighted the problems with a revocable living trust, they can be a great estate planning tool, but only if you understand how it works, that you properly manage and administer your trust, and you understand that you don't get any asset protections with this trust. In state of Washington and Idaho, your assets you put in this trust have no asset protection. And when you die, when these assets go, for example, to your spouse who gets your share of it, none of those assets are protected for your surviving spouse. You don't get asset protection with a revocable living trust, but you do avoid probate. An additional benefit is if you lose capacity during your lifetime, then a successor trustee manages those assets for you. That person is typically also the same person you designated under your financial durable power of attorney. So a will and a revocable living trust are the primary estate planning documents that are used for what happens upon your death. There are other types of trusts beyond what we just talked about, primarily an irrevocable trust. That again is a lifetime trust that you create during your lifetime. It's a trust where you give away all your assets. And why would you do that? There's all sorts of reasons. But an irrevocable trust is supposed to be just that, irrevocable. You can't change it. With a revocable trust, like the one I was just talking about, before your death, you can revoke it at any time. You might change your mind, you don't want it anymore, whatever the reason is. With an irrevocable trust, it's intended to not be changeable. You created it, it's not going to change. There's always exceptions to these rules, but that's how it's intended. Why would you ever create an irrevocable trust, or irrevocable if you prefer? The reason you would do that is maybe for tax minimization purposes. Maybe you say, my estate is too big in the state of Washington. My assets are beyond Washington's estate tax credit exclusion amount of $2.193 million. So I'm going to take and put this extra money into a trust, irrevocable trust. So you're no longer considered the owner of that asset. Great, good tax planning opportunity there, because then you won't have to pay, your estate won't pay Washington estate tax on it, which is a great planning tool. Maybe you are facing long-term care costs in the future and you just received a diagnosis of Alzheimer's and maybe you've got long-term care insurance, maybe you don't, but you want to make sure that all your money doesn't get spent on your care. Well, Medicaid's rules provide whatever you do 5 years in advance of applying for benefits, Medicaid doesn't care about. So maybe you take and put all your assets into that irrevocable trust to protect them, for example, for your children. That's another possible reason somebody would create an irrevocable trust. And I have to apologize. Once I start talking about taxes or Medicaid planning, we're kind of getting in the weeds about what is complicated. So I'm going to kind of leave it with that. There's other discussions, other times where I've discussed tax planning, I've discussed Medicaid planning, what you can do to protect assets if you're facing if that's your situation. Anybody who's concerned about estate planning basics, you are not concerned about an irrevocable trust. That is not basic. That's way more complicated. The basics for how your assets go, what is the mechanism for your assets passing on your death, is through either a will or a revocable living trust. One of the things I have to add to both wills and irrevocable trusts is that keep in mind that not all assets are governed by your will or your revocable living trust. Some assets go by way of what's called beneficiary designation. Your life insurance, your 401k, your IRA, all of those are going to pay to whomever you've directed by filling out a form that says, this is where my assets go, to this person. And keep in mind that for many people, their retirement accounts are their biggest asset. And they are directed by way of a simple form. And it's for that reason, I think, that people don't appreciate how important it is to correctly fill out a beneficiary designation. Yes, you might get guidance from your employer for your financial institution, but because that is such an important thing to get right, your beneficiary designation, just like any estate planning situation, I do highly encourage you to seek out an estate planning and an elder law attorney to make sure you get it right, because it's not until somebody has died that we know that they didn't get it right, and then we have to deal with trying to fix things that weren't done correctly. All right, so I'm going to talk about probate, but here I see that there is a question that might be good for me to answer right now. It says, I live in Washington State, but the successor trustees of my living trust do not. What, if any, obstacles might my successor trustees face by not residing here? What can I do to make the work easier for them? It's a really good question. So, assuming that your successor trustees are citizens of the United States, you don't have a problem. If they live in Canada, for example, that's a problem. Talk to your lawyer. Usually, when it comes to a revocable living trust, it'll say it's, administered under the laws of the state of Washington. Your trustee, your successor trustee, can live in Idaho, California, or elsewhere, and that's not going to be a problem. The only reason it might be a problem is if somebody tries to sue or enforce some legal rights under the trust, like a beneficiary or something. Then whoever is the trustee is actually they need to submit to the jurisdiction of the Washington courts. But simply having an out-of-state trustee is not a problem. How do you make the work easier for them? Be organized. Make sure that you have like a notebook where you have your trust, where you have a list of all your assets, the deed, a copy of the deed that shows your house is in the trust, statements of all your bank accounts, investment accounts, showing everything's titled in the name of the trust, and actually give a letter of instructions to your trustee. I mean, the trust itself will say what a trustee is supposed to do, but having a letter from the person who created the trust saying, hey, this is to give you guidance. It's just to say why I set this up and what I intend to accomplish. That will go a long way in helping your successor trustee manage your trust if they need to step in. It's a really good question. All right, let's talk about probate. Wouldn't be discussing completely basics of estate planning if I didn't talk about probate and understanding probate. There are so many misconceptions about probate. What is probate? Probate is the legal process to administer your estate. Probate occurs after your death. Probate will either be based upon your will, if you have one, or if you don't have a will, then there still will be a probate under what is called the laws of intestacy. See, if a person doesn't have a will and they don't have a trust, they don't have anything for what happens to their assets when they're gone, the state has a plan for you. The state's plan is called the laws of intestacy, and your assets will go where the state says they go. To give you some reassurance, the state doesn't grab your assets, but the state does say, oh, you're a single person, you have 3 kids, you don't have a will or any direction to your estate plan or to your assets. Your assets are going to go equally to your 3 kids, period. And that will be under the laws of intestacy. So a probate can be based on a will or it can be based on no will. But a probate occurs when there's no other way to direct where your assets go. If you had a revocable living trust that's working properly, then there's no probate. If you have an estate plan that was set up to avoid probate, maybe your lawyer said, we need a will for a backup, but there's no reason for probate of your estate. You don't need a trust. You don't need a probate. We're going to set up your estate plan to say, for example, your house transfers on death to your child, your bank account to your child, your life insurance, your 401k. We can set up an estate plan to avoid probate and not have a revocable living trust and all those complexities. Depends on your situation. So probate doesn't always happen. Your estate plan can avoid a probate if it makes sense, without a trust or with a trust. But let's say that there's going to be a probate. The will is filed with the court, or if there's no will, then somebody who is likely to be inheriting is going to petition the court and say, hey, I want to serve as the executor. The process is the court says, okay, you could be the executor, the personal representative. Then what your job is to give various notices to other heirs at law and beneficiaries and to the state, gather up all the assets, find out if there's any debts to pay legitimate debts. And then there's this net amount that's left. Maybe there was a house and the house needed to be sold, so you need legal authority, which you get. through the probate to sell the house. Now all you have is money to divide, and then you divide what is left to the beneficiaries. Through this process, I forgot to mention, there's also an opportunity for notice to creditors to make sure that any creditors who have legitimate claims will be paid, or to also cut off any creditors so that whatever is left will be divided, and you don't have to worry about some creditor later coming back and saying, oh no, part of that was mine. So the probate, that is the probate process. It is a statutorily mandated, you do this and then this, give notice here, do this, do this, do this. I think it's for that reason that sometimes people think, oh, this is too complicated. It's complicated if you're not a lawyer. If you're a lawyer, it's just a process that you follow. If you're a non-lawyer, you can try to do it yourself. We even have on our website do-it-yourself information, because we know sometimes people want to at least try to do it themselves. But more commonly, people do need assistance with the probate. Probate is not a terribly difficult process legally here in the state of Washington. It doesn't go on for years and years. Typically, we'll go for a 6-month period. If it's beyond that, it's because maybe there's a tax return that needs to be filed, or there's some complications. Probate in the state of Washington and Idaho, the fees for it are based on how much work was involved. How much work did the lawyer need to do? Contrast that with other jurisdictions where the fees are based on a percentage of the size of the estate. That's not how we do it here in Washington and in Idaho. So probate is something that, what I tell clients is, avoid probate if there's no benefit. We'll set up your estate plan that way. Or we should do a probate because that's how we're able to protect money for your beneficiaries, for your surviving spouse, how we're able to create asset protection trusts, how we're able to minimize taxes. There's a lot of very, very good reasons for probate, but your estate plan should be set up so that you understand those good reasons and that you know that probate is a smart thing to do, not something that was thoughtless and it just occurred because nobody thought through whether to do probate or not, or whether there was a estate plan or not. All right. I believe I have gotten through all the basics of estate planning. I hope I've helped you. Now that you have knowledge about what fundamental estate planning documents there are, that can help you overcome maybe some reluctance to getting started. To get started, of course, watching videos on it, reading, all of that is great. Do keep in mind that every state is different. So what I'm telling you about Washington and Idaho law likely is going to be the wrong advice in a lot of ways if you live in a different state. If you are in a different state, please seek out an estate planning and elder law attorney in your state. To find that qualified attorney, you might go to the National Academy of Elder Law Attorneys website. That's NAELA.org, NAELA.org, and that will help you find an attorney, a qualified attorney in your state. Of course, if you are in Washington or North Idaho and you want to talk with us further about your specific situation, happy to talk with you. Our phone number is 509-468-0551. Our website is elgwa.com. We also have a YouTube channel with lots of great information on it. And if we can be of any further assistance to you, answer any questions, please reach out to us. We'd be honored to help you. Thanks so much.